Thank you all for joining us on this wet and miserable Tuesday morning. My name's Lynn Mason. I'm the business manager for the West of Berkshire Safeguarding Adult Board, and you are here today to hear from our colleague, Detective Inspector Duncan Wynn, who is the head of the Central Fraud Unit for Thames Valley Police, and he's going to be presenting to us behind closed doors unmasking carer and family fraud. And this has come about as a result of our board's priority for this year, which is preventing financial exploitation of adults with care and support needs. Quick little plug just to say that there's a lot of resources on our board's website. I'll put some links in at the end of this meeting in the chat, and also any sort of references that Duncan makes throughout his presentation. There will be an opportunity for questions at the end. You can either use the chat function, or you can at the end I'll allow everyone to have access to cameras and mics they want to talk. Just to say, the actual presentation's being recorded, but the Q&A section will stop recording then. But just please be mindful of confidentiality when asking any questions. Right, so I'll just hand over to you, Duncan.
Thank you very much. Good morning, everybody. So as introduced, Duncan Wynn, I head up the Thames Valley Police Central Fraud Unit, which has been in place since 2023, so a fairly new unit, and we're in place to tackle all fraud. So we cover everything from multi-million-pound boiler room frauds right down to a £50 loss on Amazon and everything in between. So just to put some stats in context, really, I've titled this slide "It's Only Fraud" because that is my biggest kind of like battle within policing, is to convince senior management that it's not only fraud. So there's a lot of conception around the fact that fraud is harmless, it's victimless, it's just white collar crime. Why is that a matter for the police? A lot of it's civil. So what we've come in to do as a central fraud unit is shatter those myths and focus on those frauds which we really should be paying attention to, and that historically may have not been dealt with very well by the police and partner agencies. So just to put it into context, fraud now accounts for 41% of all reported crime. In fact, we also know it's massively underreported. So there were 1.2 million frauds reported to police last year, but national statistics surveys suggest that there were 4.1 million victims of fraud. So it's possibly underreported by up to 75%. So a huge problem nationally. And what we need to do as a specialist department is focus on those frauds that cause the highest harm. And one of those fraud areas is carer fraud, or fraud committed by families, which can have really high losses. So I'm just going to switch my camera off to allow a smooth transition of slides. There's a lot of information on here. I know a lot of you will be professionals and will know all this, so this is probably more of a refresher than a knowledge check, but I'll go with what the presentation is, and then I'll pause at the end for any questions. Great. So fraud committed by carers family, we know statistically targets very vulnerable people, will amount in the highest losses to victims because it can occur over a long period of time and go on behind closed doors and undetected. And it also has the biggest impact not only on the victim but the rest of the family, emotionally and financially, and quite often it ends up with the local authority picking up the bill because funds intended to pay for that victim's ongoing care has now been taken and spent by the fraudster. So when we talk about fraud, again, for a bit of myth busting, the Fraud Act 2006 completely changed the fraud arena. So prior to 2006, we had some really complicated offences to wrestle with around obtaining a pecuniary advantage, all sorts of reversions to the Theft Act, and fraud was really unclear in terms of its classification. Now, fraud is broken down essentially into 3 offences under the Fraud Act 2006. And the offence that we're really focusing on today is fraud by abuse of position of trust, which is section 41AB of the Fraud Act 2006. So essentially what this is looking at is so when you're dealing with carers and family members, it's all around whether or not they've got a specific position of trust regarding that person's finances. So a carer whose responsibility is carer's duties and sometimes goes to the shop to carry out activity for the victim or the person they're caring for, will not necessarily have a specific financial position of trust. So that's something that we're currently looking for some more guidance on from the Crown Prosecution Service. But the current guidance is if that person should have responsibility and safeguard that person's finances and had failed to do so, then they would commit the offence of fraud by abuse of position of trust. And that can apply to professionals, accountants, solicitors, carers, anybody with a position of trust, but more specifically in relation to family members, person who've actually signed and agreed to be a lasting power of attorney or deputy for that person. So they're all people who fall into that category. If they don't have that specific position of trust, then we're looking at offences of theft or straightforward fraud by false representation. So made a dishonest false representation with a view to causing a loss or a gain, or quite simply appropriate the property belonging to another with the intention of depriving them of it. So those are the fraud and theft. But from a professional point of view, or from a point of view where you've got suspicions that somebody's being financially abused, then the actual right thing to do is to flag that immediately. Let's not get into the weeds around what the offence might be. Financial abuse is a nice overarching phrase that we can use for somebody who's having their money taken away from them in suspicious circumstances. That should be reported, and then we can look at what specific offences we're looking at. One of the big battles, again, is that the criminal threshold is very high. We have to prove our offences beyond all reasonable doubt, and the Crown Prosecution Service will want to see clear evidence. So what we would like to see is early reporting of any suspicions or concerns, so we can start our evidence gathering as soon as possible. And whether or not you're unsure as to whether it might be a civil or a criminal matter, the advice is to report it, because that is one of our roles as a central fraud unit, is to assess those matters and work out which are civil and criminal. And I have to say, looking back historically, the police haven't done a great job of recognising when abuse by someone in a position of trust, and particularly a power of attorney, is actually a criminal matter and not a civil matter. So it's also almost been seen that they're a family member, they've got a power of attorney, they've used some money to pay for a holiday with the person's consent, and that's absolutely fine, when actually that would be a clear breach of a power of attorney, which I'll come on to shortly. Quite often we've got victims unable to give clear evidence, and in fact, sadly, in a lot of our cases, the financial abuse only comes to light after the victim has passed away, and then we've got real issues in convincing the CPS that, for example, it wasn't a gift. So the gift defence is one that's raised quite often in these circumstances by saying, prior to the person dying, they said they wanted me to have the money, and it's very difficult to disprove that to the required criminal level of evidence. And again, the suspect may have partial consent, so the victim may have given the suspect consent to use their bank card, and then they've overspent, and then you're in a bit of a grey area then as to what was given permission and what wasn't. So we'll run through some case studies, some real life cases that we've got within the Central Fraud Unit, which will hopefully give you an idea of the pitfalls and issues we've got, and then we can start looking at what good and bad practice looks like in relation to these kind of cases. So the case of R versus S, the suspect was one of several caregivers in a home care situation with the victim. So an agency supplying carers who'd go in shifts to provide care for a bedbound victim. The daughter of the victim lived abroad and identified some financial anomalies. The evidence showed that there was systematic financial abuse by the carer. So when we started looking into the bank accounts and carried out an arrest and a house search, we found this carer had been booking flights for his wife to come over from Africa, some dental work, some cosmetic dental work, and designer clothing, all purchased using the victim's bank card. The victim had passed away before the suspect had been arrested, and there was a coronial inquiry into that, which delayed matters. The suspect claimed in interview that the victim had consented to the purchases and gifted the items to him. We took this case to CPS on no less than 6 occasions, providing further evidence as requested by them on each occasion. And even though we provided evidence from hospital records that the victim lacked capacity, in fact, she was undergoing treatment in hospital, having been admitted at the time of one of the last purchases, the CPS would not authorise charges. So even though we showed the victim did not have capacity to give consent, the suspect had used her bank card for purchases were completely out of keeping with what the victim would normally allow a carer to do. He was the only carer who apparently had been given gifts. The CPS would not prosecute that case. So this isn't evidence to show how high the threshold is in terms of prosecuting these cases and how difficult they are. In a fair wind on another day with a different lawyer, we may have got a different outcome. But essentially what the CPS was saying is, if he says it was a gift and we've got no evidence from the victim to say it wasn't, we cannot prove beyond all reasonable doubt that wasn't the case. Without any other supporting evidence from somebody to categorically say that the victim wouldn't have given that gift, that's where we were in relation to that case. So contrast that on to the case of RVDF. The victim and suspect met in a local pub where the suspect was working behind the bar. The victim was very isolated and suffering from various medical issues. They became friends, or one would say that he was groomed into a abusive relationship. The suspect then began to block families and friends visiting, carried out a lot of the caring responsibilities herself. The victim was on one occasion found collapsed in his house. There was a fear for welfare call from the family to the police, who entered the property, found the victim collapsed. When he went into hospital, the family reviewed his bank statements and found over £200,000 that they expected to see in the victim's accounts to be missing. We then carried out an investigation. The financial inquiries revealed that there were large online bank transfers to the suspect's accounts. Her only explanation she can give was again that he wanted her to have the money, that she had actually given him money to put away and save for her, and this was him paying back her own money to him. So the interview didn't stack up at all. It didn't comply with the evidence. Despite being very vulnerable, the victim was able to say that he did not give the suspect permission for that, had given her access to his bank card for shopping, but had not allowed her or given her permission to set up online banking. That had been done without his permission. And then following a submission of a case to the CPS, that person has been charged and is awaiting trial. I'm very confident that there'll be guilty pleas and convictions in relation to that case. Yeah, sorry, I should have argued the initials are there because the person's awaiting trial and not convicted yet. So DF is the initials of the female suspect in this case, which will be reported as and when it comes to court. So a successful prosecution. So R versus Susan Brulin. This has been widely reported in the media. In fact, is subject to a Crime Watch Solved documentary, which is going to be aired next year. So this is a case of Susan Brulin, who was a accountant and financial advisor from Banbury. She became friends with her old neighbours, a couple called the Rumpkes. Very financially well-off couple. Sadly, they both suffered with ill health, one with dementia, one not, both put into separate care homes. She then stepped in to take full financial control and successfully got power of attorney over the person with capacity, which by virtue of that gave her power of attorney over the person with dementia, because the person with capacity had a power of attorney for the person without capacity. So this then gave her sole access to all accounts. She then stopped paying the care home fees. She then liquidated all of their assets through investments and the sale of a house, filtered down £900,000 in total from their accounts and spent that on her own businesses, recovering losses from a couple of businesses that she run, and also purchasing cryptocurrency through some Russian exchanges where she may or may not have been a victim of some sort of cryptocurrency scam herself. Either way, she clearly abused her position of trust. She clearly acted not in the interests of the donors. A straightforward case of fraud by abuse of position, and she was sentenced to 5 years imprisonment. Being a person of previous good character, it's a really good sentence. It's up there with offences of serious drug supply and robbery shows the seriousness and the impact of these cases. And there's also Proceeds of Crime Act proceedings going on where we have got charges over her house, her vehicle, a number of other assets, and we're chasing money through the cryptocurrency exchange to try and recover as much as we can on behalf of the victims and their family, but also on behalf of the local authority, because obviously they've now got unpaid care homes for both of the victims, one of which is still within a care home and one of which has subsequently passed away. So there's some real life cases which show the pitfalls of these offences, but also shows that there is a shift. We are now much more adept at dealing with these kind of cases. We have got specialist officers within the fraud team who fully understand these cases, and quite importantly, we've struck up a partnership with a solicitors firm called HCR Hewitsons in Northampton, who specialise in family law power of attorney, and we actually instruct them to give expert evidence on quite a few of our cases, certainly to give officers guidance in relation to their interview plans and house searches, but most importantly to provide that extra bit of assurance to the Crown Prosecution Service that this person has breached their position of trust. So that'd be around, particularly around gifts, where it is actually an exception to the power of attorney that you shouldn't accept gifts. So we have some very strange cases where we've got two siblings looking after a parent's finances. One has a power of attorney and one doesn't. In those circumstances, the victim or the person with the finances is able to gift the sibling without a power of attorney, but not able to gift the sibling with the power of attorney unless they declare it to the Office of the Public Guardian. So there's quite specific responsibilities for somebody with a power of attorney regarding gifts, and not declaring it, not registering it and accepting gifts beyond the reasonable amount that would have been given by the donor prior to them losing capacity is really good, clear evidence of abuse of position of trust. So the signs to spot: sudden changes in bank accounts, including unexplained withdrawals, large sums of money by a person accompanying the older person, changes to names on the bank account. So we do a lot of work with the banks under the banking protocol, and also a lot of work on now what is called the reverse banking protocol. So a lot of our job is to, when we get any early indication of potential financial abuse, is to make sure the banks and the financial institutions are aware. They are very alert to this. They have anti-money laundering responsibilities. They also have a responsibility to spot financial abuse and safeguard their customers. So they will spot that by noticing some unusual transactions on accounts, so high spending abroad, suddenly using online banking when online banking hasn't been used, for example. But equally, if you were to bring into us a suspicion of financial abuse, the first thing we would do would be to do a reverse banking protocol, which is us notifying the bank of potential vulnerability of their customer, which would prompt an account review, and they could submit a confidential suspicious activity report into the central fraud unit, giving us an overview of the account, which would be our starting point for an investigation. For example, if they reviewed the account, suddenly realised that a named person had been added on the account with no explanation as to who they were and what their responsibility was, a power of attorney had been invoked without actually the person losing capacity, or suddenly there was spending not in keeping with an elderly person living in Reading, for example, there was spending on online shopping or holidays abroad, or expensive shopping in London or Manchester, whatever it might be. So they're the kind of things that they should be looking at. I'll come to questions at the end if that's okay, but keep them coming. So there's some really good questions coming in that I can see. So all of those red flags are what we'd expect to look for, and we will share this presentation. I've also got some information sheets as well that we've produced in response to this particular crime type. So misuse of power of attorney deputyships are an absolute flag. I'm sure all of you have had various dealings with the Office of the Public Guardian. They will accept that they're understaffed. They will accept that they will only be reactive. So the one thing to remember with somebody with a lasting power of attorney, they can pretty much carry out their activity under the radar and unseen, because there is no obligation for them to submit any accounts or records. So it's only with a deputyship that you need to proactively submit accounts and records. So it's advisory that a lasting power of attorney keeps records. It's advisory that they record spending, etc., but it's not actually a function that they need to submit. And that's something that's being lobbied for change through some work we've been doing with HCR Hewittsons and various members of Parliament, because it does seem that it is too easy to misuse a lasting power of attorney, although they do clearly have a value. So as a local authority or carers, the sudden influx of unpaid bills, bills being paid late, financial issues coming to light would be a red flag for potential financial abuse. Missing articles, missing high value items, etc., again, as a power of attorney, moving valuable items, selling them, etc., may not be in the interest of the donor. And I think that's the key message, is anybody who had lasting power of attorney must make decisions that are in the interest of the donor. And if you come across any decisions that are questionable, that's when we should be flagging it as early as possible as potential financial abuse. Because again, there's this misnomer that a power of attorney can act exactly as the donor, which is true, they can, but every decision and every transaction must be in the interest of the donor. So it's very difficult to justify why you're putting all of your Amazon shopping or your Just Eats on the donor's bank cards, because why would that be in the interest of the donor? You start giving gifts of £200 or £300 to the grandchildren for Christmas, when prior to losing capacity, the donor would give gifts of £10 or £20. So all of those are signs of financial abuse. And also being paid for the service of being the lasting power of attorney. There are in some circumstances where expenses can be claimed, but it's not a paid role. So again, anybody saying, well, yeah, I take that money out for what I do for this person, that is not actually included in power of attorney. And then one of the main red flags is isolation. So as you can see in the Bruland case and the DF case, one of the main tactics by the suspect was to completely isolate the person, take complete control of their finances, get control of online banking, limit the number of people who come to visit the victim, giving excuses as to why they're not able to receive visitors, etc. Make it clear to the care home that they are the main contact, they are the only contact, they're the only person that cares about the person. They are all, again, potential red flags to financial abuse. So good practice would always dictate that there's one or two people carrying out the activities on behalf of a donor. Ideally, the person carrying out the transactions, and then someone whose role is to review the transactions and make sure they're in keeping. That protects not only the donor, but the victim at the same time. So it's not only just about protecting the cared for, it's also about protecting the carers, because again, carers can put themselves in very vulnerable positions in terms of accusations if they don't carry out good record keeping and have that third party oversight. So at the first signs that somebody is losing capacity, it's a really good time to start looking at how that person's finances are going to be managed going forward. So if there's no power of attorney in place and they've already started to lose capacity, it's a deputyship. If they've already got a lasting power of attorney in place, then you can think about invoking the power of attorney at that point. Again, good practice would suggest that there's audit trails. So any transactions that are carried out are specifically recorded and documented and signed off by an independent party, that you set up specific accounts for the purpose of carrying out that activity. It can get really messy if transfers are made from the donor's account into the power of attorney's accounts to carry out stuff. It's always better for the donor to have either a separate account to operate as a power of attorney in both theirs and the donor's name, or a sub account where the power of attorney has a specific named person on that account with their own cards to operate from that account. When we then come to forensically review the spending, it's very easy then to differentiate between those transactions carried out by the victim, and those transactions carried out on behalf of the victim, because that's where we can get into a really grey area. For example, we've had a lot of cases where persons who's given financial responsibility go shopping as they do every week, but use the victim's card, which potentially, if dishonest, could be fraudulent in itself, because they're falsely representing that they are the victim when they spend on that card. But they will carry out the shopping for, say, £12, £15, whatever it might be, and then go to the ATM and draw as much cash out as they can. It could go under the radar for, anything up to 18 months, 2 years, and you could be getting into the £50,000 to £100,000 under the radar, because the bank wouldn't necessarily detect them as suspicious transactions. It's being done with the victim's card, and it's very difficult then to work out what was done on behalf of the victim and what wasn't. So that's why we look at that. So joint accounts are a really good idea, with separate cards to show which cards you were using whilst acting as power of attorney, and which cards you were using, for example, when out shopping with the victim. So LPAs and deputyships are an absolute must, and properly signed off by solicitors. So we have had some that have been signed off by will writers and aren't potentially legally correct. So we would always advise to get a fully accredited SRA registered solicitor to oversee powers of attorneys and deputyships. It will be more expensive, but in the long run, it's about the safeguarding. So always have third party ownership and family involvement. So 2 or 3 people involved in the managing of someone's finances is always better for checks and balances. It means that people are accountable. It means that audit trail can be looked into and shared at any point, and it will mean that any financial abuse is detected early, but also acts as the ultimate deterrent to somebody carrying out financial abuse or wanting to carry out financial abuse, knowing that every week or every month the bank accounts are checked and the spending is questioned, is a really good deterrent to preventing somebody committing financial abuse, and also having that professional oversight, either through solicitors or care professionals, to look at finances in the same way as you would look at other vulnerabilities. So good practice: weekly bank statements reviews and flagging anything that's unfamiliar, transaction alerts and daily spending limits. So again, particularly one to protect carers and the cared for, but also to prevent fraud, is to have separate bank accounts. So if someone is receiving a large pension or has a large amount of capital, that should be in a lockdown account at the bank, and then there should be a sub account which is for daily spending, which maybe a transfer of £200 a week goes into. So if that account did become susceptible to fraud, the most that the fraudster is going to get away with is about £200, and the most that an unscrupulous carer or visitor to the house or family member can get is £200, and anything else will be flagged by the bank. So that reverse banking protocol puts a vulnerability flag on the account. The bank will then work out the best way of safeguarding money, and then put various flags and transaction alerts on. So if suddenly there was a transaction to book a cruise for £5,000, that would flag and then would obviously get reported and questioned. So really important that we include the financial institutions in this. So again, more fraud protect advice around not sharing the pins, never writing them down, where carers or visitors can see them, because again, if the bank card and PIN number are in a jar on the coffee table, and whichever carer comes in can then use the card and the PIN to carry out shopping, if there is financial anomalies on there, proving who did it, etc., is going to be fairly difficult. Whereas if there's a specific card for the specific named carer or person carrying out those financial transactions, the audit trail is much clearer. So carers shouldn't be using the victim's bank card on their behalf. They should have a separate one. Cash unsupervised, again, leaves the carer and the cared for vulnerable. And online purchases should be formally agreed, and there should be an audit trail and a rationale as to why they're carrying out those online purchases. Because again, we've had defences saying that the donor has set up the victim's credit card on their Amazon account to carry out purchases on behalf of the victim, and then didn't realise that was the saved card, and then all the transaction afterwards were an accident. Highly unlikely, but probably enough to put enough doubt in the mind of CPS to not charge that case. So again, keeping things really separate, keeping audit trails is really important. And again, locking away checkbook cards, passports, benefit letters, etc., will prevent somebody having access to enough information to carry out identity fraud on behalf of the victim. So if you think about it, if you're a carer or you've got power of attorney, you've got access to a huge amount of private information, enough information to be able to open up accounts in the victim's names. And quite often financial institutions, providing they've got enough information, i.e. a copy of a passport, an email address and a benefit letter, for example, or a utility bill, that would be enough to open up a bank account. If it's done from the IP address of the victim, it's going to be really difficult to prove that that wasn't done with the victim's knowledge. So again, making sure all of those documents, etc., are secure is really important. We've even had tradesmen open up accounts in victims' names because they've asked for the victims for proof of ID for a bank transfer, taken photographs of the victim's ID, and that's given them enough information to then go and open up bank accounts and take out loans, etc., etc. So professional boundaries, really important. Again, this is all on the handover, but the top headlines there are to maintain the professional boundaries, not to accept gifts, loans, or thank you cash. Again, the policies all around this should really be written, but if not, if in doubt, a box of chocolates, a bottle of wine at Christmas on birthdays, acceptable gift, £1,000 to pay for cosmetic dentistry or whatever it might be, or gifts for your children or whatever it might be, unacceptable. So it's really about maintaining those professional standards. It's advisory to avoid shopping or handling money without written authorization. So again, if there's a power of attorney in place and the person's lost capacity, that's where the written authorization would come from, or some kind of written contract around carrying out shopping, how it's going to be done, where the audit trail is, what the receipts are going to look like, etc. So records and receipts of every transaction. Use petty cash where possible, because that's a much better way of doing it. If you know the victim shopping comes to about £80 a week, then somebody leaves that £80 with receipts, and then it can be audited very quickly, and we're not getting into access to bank accounts, which can potentially lead to large financial losses. Understanding safeguarding duties and speaking up early. So we really encourage people that any sign of financial abuse, however small, report it early, because that's when we can stop the large losses and put things in place. And it may be then you're looking at discipline and bad practice rather than fraud by abuse of position if we can stop it early. And again, that can be through the care agencies or through safeguarding team or directly to the police. So quick rundown of the various legal orders that are available, and we've actually completed a information and handout sheet in relation to this, which will go on our social media and websites, but also be available via your portals. So a lasting power of attorney can be for property, finances, health and welfare, or both. So two separate power of attorneys if you want to cover them all, or you can have a separate one for property and finance, a separate one for health and welfare. The donor nominates one person minimum, but can be as many as 4 or 5. Best practice is at least 2. So you've got that oversight and balance. The person must have capacity in order to give power of attorney to an individual. Again, if done through solicitors, they will be extra diligent. They will carry out checks with the people nominated, but more importantly, they will carry out checks with other relevant parties like the local authority, like the care home managers, like other family members, and check that they are happy with the nominated powers of attorney. So in the case of Brulin going back, the family had no idea that Susan Brulin was the nominated and only power of attorney for their elderly relatives. And had they been, they would have questioned the relationship, etc. A quick inquiry with the care home manager would indicate this person never visits, they haven't visited for 2 years. Why are they suddenly power of attorney? So those checks and balances won't necessarily be put in place if it's done directly online or done via a will writer. So solicitors will have a much higher degree of due diligence in relation to that. You may still see enduring powers of attorneys. they could be applied for and issued prior to the 1st of October 2007, but are now obsolete and have been replaced by lasting powers of attorneys. But should a victim lose capacity who had an enduring power of attorney in place before October 2007, that would be the legal power that is executed, and that's what the person will be acting under. Again, fairly uncommon, but essentially only covers property and financial affairs, doesn't cover health and well-being. It had to be registered prior to 2007 and has to be executed and registered with the Office of Public Guardian at the point the person starts losing capacity. So again, once someone executes that, they're duty bound to act in accordance with it, and that's again where the misnomer comes in, where someone executes the enduring power of attorney and believes they can do what they want with the financial assets. And quite often this is where we see fee dodging or inheritance tax dodging, where families will take advice which is not necessarily ethically correct around minimising the amount of assets the person's got in order to get below the threshold for care home fees or to avoid potential inheritance tax charges. So they would, for example, put the person in a care home, sell the family property, and then gift the proceeds to various people. That would not be in keeping with acting in the best interest of the donor and would be abuse of position of trust. But again, a complicated area, and you'll see a lot of this talk on the internet around what people call asset management, which by all accounts and essentially is actually fraud. And again, sadly, the victim ultimately in terms of finances can be the local authority, because when they come to do the financial checks to see if that person is liable to pay their own care home fees, you'll find that they've only got £30,000 in assets, and the £400,000 or £500,000 they had on them has been dissipated by the family or the power of attorney. But again, that's something that we would look into, take advice on, and potentially prosecute for abuse of position of trust. So the most common one you'll see is the lasting power of attorney, covering either property and finance, health and welfare, or both. And then there is an ordinary general power of attorney, which can be used whilst the donor retains capacity, and this is generally short term. So, for example, if the person was incapacitated in hospital and couldn't carry out their bill paying, etc., you can get a ordinary or general power of attorney for 6 months to carry out their finances on their behalf. But that's only while the donor's got capacity. So it's basically essentially a more advanced version of a third-party mandate. A third-party mandate being something you can informally arrange with a bank to give you temporarily control of a person's bank accounts, but again, with consent and with somebody who's got capacity. So attorney's responsibilities, again, every single person who takes out a lasting power of attorney is given the guidance documents via the Office of the Public Guardian. It explains very clearly the guidance around keeping audit trails, keeping records, only ever acting in the interest of the donor's best interests. And they've got a duty to keep records and accounts to the OPG. However, as I've already pointed out, the pitfall in this is reactive. So only if someone raises concerns or the person dies and there's an investigation will the power of attorney then be asked to produce records and accounts. I personally think it should be an annual report that they need to fill out as their responsibility of an LPA, where they are obliged legally to create that document, share it with a third party, have it audited and checked and submitted to the Office of the Public Guardian. It's a massively huge responsibility. We need to protect the people who have donated the power of attorney, but we also need to protect those carrying out the activities. And the easiest way to do that is to have regulation and to have accountability. And I think that would be a really good change. So the restrictions to an LPA is that they can't be paid for it. They need to keep money separate. And they've got to get authority from the Court of Protection or the OPG in relation to potential conflicts of interest, so investments, that kind of stuff, gifting and loans. And a lot of people who have power of attorney will see an opportunity to, inverted commas, get their inheritance early. And if they are the main beneficiary of the will, they will see, well, why can't I just have the money now instead of when the person dies? But again, there's specific guidance around lasting power of attorneys and how we do that. And essentially, just because they are the main beneficiary of the will doesn't mean that money is theirs, because clearly probate has to take place. The debts of the estate have to be settled prior to any awarding of the funds from the estate to a beneficiary. So again, lots of legal process to take place, and wholly unadvisable for somebody to start taking money that they think is theirs when actually, specifically within the legislation, it says it's not. So all decisions must be reasonable, justified, and proportionate, and again, advisable to record rationales to those decisions, but because it's reactive, most people don't. Again, a change in legislation and regulation would mean that, for example, if the elderly person had always wanted the family to go on a holiday to Disney, and that was well documented with a rationale and witnessed, and £10,000 was spent on that holiday, I don't think there would be too many eyebrows raised. It's only when retrospectively you look back, £10,000 was spent on a holiday to Disney for a bed-bound victim, that's when the eyebrows and questions come. And without an audit, a rationale at the time, not retrospectively, it's very difficult to prove or disprove whether there was dishonest intentions around that. So, bit of a grey area there that needs closing up with some loopholes. And there is a report that's been produced on that that's gone to MPs that I can share if people have a specific interest in getting involved in lobbying for this change in legislation. So deputyships, slight higher threshold for this. So they have to be applied for through the court protections. They have to be signed off by a judge. The application process is quite intense. The person who is to be appointed a deputyship has to be checked, has to be verified. Other family members and interested parties will be formally written to and asked their views on that person in terms of their suitability to be a deputyship. Generally, they're also asked to take out a bond. So if, for example, they have got financial control over somebody with assets of £500,000, they will need to take out an insurance bond to cover that loss. And that's really important, particularly when it could end up to be fees owed by the victim to the local authority. If that bond is in place, then essentially that is an insurance policy that means that the funds are misused by the deputy, then an insurance payout will repatriate that loss. So I think that's a really important part of the process and something that should be considered for power of attorneys as well. So just be aware, a deputy order can take up to 6 months. So again, that's where we see potential financial abuse, where the person has clearly lost capacity or losing capacity, should not be applying for a lasting power of attorney. It should be a deputyship. And quite often, because of the complications, the amount of time it takes, people can run round to a local will writer who may or may not be capable of assessing whether or not somebody's got capacity, will assume that they have got capacity because there's no formal diagnosis to say they haven't, and will authorise an LPA taking place, which is clearly inappropriate. So 6 months is too long. It all goes through a central court, I think in Bury St Edmunds. They are trying to streamline and speed up the process, but because it is such a high power to grant on somebody, it needs to take time, and it does need to be vetting and checking taking place. So once someone's got the deputyship, they can act completely as the donor would have acted. So again, once they serve that on financial institutions, they can act exactly as the account holder would act in terms of banking legislation. So the bank would allow that person to carry out whatever transactions they thought were appropriate. And again, the only audit trail is the annual review back to the Office of the Public Guardian, although, sorry, not the Office of the Public Guardian, the Court of Protection. The Court of Protection are a bit more proactive, and certainly for large gifts or large transactions, investments, then the advice has to be sought prior to the financial transaction taking place. So in summary, lasting power of attorney, if the person's got clear capacity and clearly understands the implications of granting lasting power of attorney to the people that they want to appoint it to, and those people are appropriate. If there's a suggestion that the person is losing capacity or has lost capacity, you cannot apply for a lasting power of attorney. It has to be a deputyship via the court protection, which comes with increased protection, including capacity to recover money through a bonding scheme. So good practice for LPA and deputyships, always to keep finances separate from their own accounts and to keep clear records of all spending done on the person's advice. And again, as I say, we're starting to share this via information leaflets across the community safeguarding portals and wherever we get the opportunity. So following a successful conviction into one of these cases, we would then do immediate releases, and we'd include those information sheets to try and get away from these myths around what a power of attorney can and can't do, because I think that's really important education piece, not only for people carrying out those duties, but people who are considering giving lasting power of attorney, to make sure they choose the right people and they've got the right checks and balances in place. So capacity all comes down, as I'm sure you all know, to the Mental Capacity Act. Our difficulty is, from an evidence point of view, unless someone is professionally documented and assessed as lacking capacity, then we will be really struggling to prove that at the time the person didn't lack capacity. There have been cases where we've got hold of people's medical records and got professionals to go back and try and put a moment in time when that person lost capacity. And in those cases, we've been able to charge fraud by abuse of position at the point they're deemed to have lost capacity and charge the offences after that, because the person can't possibly have given consent from that point onwards. And we've separated the financial transactions, but really difficult unless there is a professional documented assessment. So we would want to see somebody who we can get a witness statement from to say, at this point in time, I assessed this person and I can state they did not have capacity to make that decision. They did not have capacity to give that person consent, whatever it might be. And that would be the required standard to take to CPS. So quite often we deal with a lot of cases where it's absolutely clearly obvious that person did not have capacity, but without that documented assessment, we really struggle. And I know there's a massive waiting list and backlog for memory clinics at the minute, but it's really important that we try and fast track these assessments, because that formal diagnosis is absolutely key to any abuse of position of trust, because it completely eliminates the gift defence. So the gift defence is the most common one raised by people and the most difficult one to disprove. So that documentation is really important. So this is the guidance we give out for care providers. So again, some companies employ a large number of employees, and it may just be one rogue employee, one person who hits particularly financial hardship, somebody. Quite often we find that suspects, particularly in the large value cases, have got an addiction issue, a relationship issue, maybe a victim of fraud themselves, may be chasing and trying to recover gambling losses, whatever it might be that can lead to financial abuse. So enhanced DBS checks are really important. References are really important. The reasons why they may have left a previous employment, again, really important. To make sure there's written policies on handling cash, gifts, deputies and appointeeships. Again, a carer shouldn't really be the person who's appointed as a power of attorney. Neighbours who pop in and look after the victim, potentially not the most suitable person to be the lasting power of attorney. So all those questions and balances around appropriate people, safeguarding. If it is a neighbour, is there even a remote family member who can be appointed as a joint power of attorney? At least then they can have oversight, check the bank statements, etc., etc. So all of those safeguarding measures. Never allow lone staff to manage finances without oversight. So that oversight and accountability is really key. Making sure the training and culture takes into account the risks around financial abuse, not only to the person being cared for, but also the carers themselves, and have a culture where people feel safe to raise concerns, because quite often it will be a fellow carer who will be the person who can and will spot financial anomalies. For example, parcels turning up that are clearly not for the victim, noticing when they go to draw money out on behalf of the victim, even though it's inadvisable to do so, maybe spotting transactions that are out of keeping or the balance is particularly low, whatever it might be. So raising those concerns at a very early stage will prevent further financial loss and allow investigation and disruption. So the spot checks on financial records, and again, just having that policy whereby if they are carrying out transactions on behalf of the victim through need, i.e. going shopping, that is a very temporary low value arrangement and is quickly corrected by a formal process with receipts, etc. So moving on to long-term protect. So we have our Thames Police Fraud Protection Toolkit. Hopefully this is being widely shared across all the community partnerships. We've essentially streamlined all of our fraud protect advice into one toolkit. This covers all sorts of financial abuse advice for carers, how to apply for power of attorneys, etc., but also your general fraud advice around online shopping, investment fraud, career fraud, etc., etc. And in addition to this, we regularly produce information sheets. So we've got one on online shopping, one on investment fraud, and we've just produced 2 new information sheets on power of attorneys and carer stroke power of attorney fraud, which I'm sure Lynn will share across the platforms. So that finishes my slides. Hopefully a good overview, and we've got plenty of time for questions
today, and we will keep our website up to date. We've got a financial exploitation webpage for the board with lots of your documents on, and the documents that you referred to today, I'll make sure are on there as well, and this video as well. So I just want to say thanks ever so much, Duncan. It's been really insightful, and I'm going to say you've given a lot of support to the board on this priority over the last few months, and it's been really helpful. And I'm keen to see the benefits of all that in the coming months of this awareness. And
yeah, absolutely. I'm absolutely convinced the answer is partnership working, and I think breaking down those barriers and just coming and asking us. If it's not for the police, we'll soon tell you. And likewise, if we need information from you, we'll ask for it. So keep that going, and really positive stuff. Thank you very much for your attendance and attention, everybody, and great questions.
Great. Thank you.